morning. So I did a little research during the break, and I failed to let Viet know that lawyers are exempt from the public holiday provisions under the Employment Standards Act. So he can be required to work on Labor Day. And after Eldad's conversation on tax, he will also be taxed on any income that he receives for that Labor Day work. So, you know, we've covered all angles. I'm very excited this morning to have this discussion on mental health and to be joined by Tara and Marty. I don't think there's a week that goes by that an HR practitioner now is not dealing with some sort of mental health issue in the workplace, or some worker that's come about, or we're hearing about it in the news where a worker has been terminated, and you know, the term going postal back in the workplace, or stabbing someone in the course of the termination because they haven't reacted well. And you know, what were maybe signs leading up to that the employer could have looked for differently. And so it's great to have Tara here, who can, am I losing Mike? Who can talk about some of the signs that should be looked for in the workplace. It's interesting when you look at some of the statistics in Canada that mental health is no longer an issue that we can ignore. And I think we've tried to deal with the stigma of talking about mental health, but in the workplace we're still a little bit shy on it. But when you look at that, 500,000 Canadians are unable to work due to mental health problems each week in Canada. That's a staggering statistic. We are not that large of a country for 500,000 people to be unable to work. 1 in 4 Canadians will suffer from a mental disability. Again, you know, look around the room. That's a lot that are suffering from some form or another, or for some reason or another. And the cost of mental illness. You know, I was at a conference with an insurance provider now who's saying that 50% of the claims coming through have to deal with mental disability. And that's not something that we would have seen 10 years ago. Or at least if we saw it, we weren't really talking about it. But now mental illness costs the Canadian economy an estimated $51 billion each year. $51 billion. And the number is estimated to go up year after year. That's a huge cost to the Canadian economy. So what has sort of been the response from the various government agencies and the legal framework? And that's what Marty and I are sort of going to cover off, is some of the legal framework. In 2012, the Ontario Human Rights Commission began to look at mental illness a little bit more in depth, as some other government organizations, and the Canadian Mental Health Association has also been producing more studies. But the Ontario Human Rights Commission specifically produced a report called The Mind That Matter, report on the consultation of human rights, mental health, and addictions. And from that, they addressed a lot of different areas of mental health affecting services, affecting accommodation, and how people are treated. But they also addressed employment, and they found in their report that many employees do not ask for help with a mental health issue or an addiction because they fear being discriminated at work, including loss of job opportunities, increased scrutiny, and dismissal. And so that really creates a lot of fear amongst the employees for coming forward and being able to talk about it and get help. And that's something that the Human Rights Commission is now addressing through their various consultation pieces. The Human Rights Commission also found, when they reviewed studies and met with others, that people with mental health issues suffer from higher unemployment than the general population, are underemployed in part-time low-income jobs, according to the studies that they reviewed. The Commission also found that persons with mental disabilities report being subjected to added performance reviews in the workplace, discipline, and dismissal from their jobs due to their mental disability, or at least the mental disability forming a part of some of the performance issues that may have come about that are creating the person maybe not performing well due to a mental disability. And that's why Tara's conversation this morning of looking for the signs and being able to come in and try to help a person through your EAP providers or whoever you do bring in is so important, because maybe if the person did get help, they could perform better in the workplace, and you're not getting into what Marty's going to talk about, is the liability issues that can come of it. So what's the legal framework? Well, I think we all know the Human Rights Code. It covers that a person has a right to be free from discrimination in the workplace, and it addresses a number of grounds. We've been familiar with the sexual harassment, we've been familiar with racial discrimination. It also covers disability. And disability, not only does the person have the right to be free from discrimination for it, they also have the right to be free from harassment. So if coworkers learn, or someone has been off from work due to a disability, the person that comes back has the right to be free from any harassment from their coworkers or their supervisors due to their disability, and that's specifically addressed by the code. The code's definition of disability, and when I reread that, it was very interesting that points A only deal with physical disability. All the other points actually deal with some sort of mental disability or can cover mental disability. So B, a condition of mental impairment or developmental disability. C, a learning disability or a dysfunction in one or more of the processes involved in understanding or using symbols or spoken language. D, a mental disorder, or an injury or disability for which benefits are claimed and received under the Workplace Safety and Insurance Act. And I'm going to address some changes that have come about on the WSIB perspective, because I think that's something that employers need to note going forward. So disability is certainly covered and protected under the Ontario Human Rights Code, and someone has a right to be free from discrimination and harassment due to their mental disability. Other forums that employees can look to is the Occupational Health and Safety Act. What's interesting, though, and I thought what surprised a lot of employers, is when we talk about workplace violence, it really only focuses on physical injury, and that's fairly consistent amongst the provinces in Canada, is that physical injury is required to trigger the provisions of the workplace violence under Bill 168 here in Ontario. And what that means is you don't have to do risk assessments if there's not a risk of a physical injury in the workplace under the Occupational Health and Safety Act. Where mental disability might be covered under the Occupational Health and Safety Act is workplace harassment, and that's engaging in a course of conduct engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or reasonably known to be unwelcome. And that is where mental disability can come into play, is where a worker is being insulted. There's a case where a doctor was telling a nurse to shush from the operating room, and that was viewed as sort of unwelcome conduct in the workplace. But the Occupational Health and Safety Act is very limited then in how you address it, because really occupational health and safety only requires for workplace harassment that an employer have a policy to address it and that they have some sort of investigation protocol. It doesn't require any sort of assessment of risk for mental illness or assessment of conduct that might lead to some sort of psychological harm of a worker. That's not within the scope of the Occupational Health and Safety Act. Some other provinces, though, have now looked at their workplace violence. We've been working with it for a couple of years now, the legislation, and they've decided that they do need to go broader. And Ontario did have a lot of pressure in Bill 168 hearings to address psychological harm. A lot of workers' groups and unions wanted psychological harm in there, and it was not put in. In the end, it was still limited to physical injury for workplace violence. But British Columbia has recently enacted provisions for bullying in the workplace, so it can address where somebody is bullied and then they have some sort of harm, whether it be psychological or physical, that comes about it, where an employer is now required to address it. Manitoba, their workplace harassment provisions actually specifically mention psychological harm. Quebec was the first province, and they were probably the first province that actually had any sort of workplace violence legislation, and the fact that they addressed psychological harm in the workplace, and that an employer had obligations to ensure that an employee was free of psychological harm. If not, they can actually complain under their Labor Standards Act. And then the federal government probably has one of the most broadest definitions of workplace violence, that they include harm just generally and any injury, and they don't limit it to physical. So that can also include any sort of mental harm that's caused to a worker by an incident in the workplace. But that doesn't mean because Ontario's Occupational Health and Safety Act only specifically limits to physical injury, that you just stop your risk assessments and you don't look at whether or not there's any conduct in the workplace that can create some psychological harm to a worker. There's the general duty clause under the Occupational Health and Safety Act, which is the Ministry of Labor's catch-all, that if it's not addressed somewhere else, they'll try to put it under 25(2)H. And so an employer has a duty to take all reasonable precautions, every precaution reasonable in the circumstances for the protection of a worker. And what that can include is addressing mental health issues. So if an employer knows that there's been bullying in the workplace and takes no reasonable steps to deal with it, you can be looking at an order under 22(5)H. We haven't seen too much of it come about until we saw a CSA standard get published, I guess about a little over a year ago now, the CSA standard on psychological health and safety in the workplace. And the Ministry of Labour will often look to this standard as determining the reasonableness requirements for employers. That, you know, what this standard addresses should really be what employers are looking at for best practices in their workplace. It is a voluntary standard. It has not been made in law anywhere here in Ontario, and I can't find it in law anywhere in any of the other provinces. But again, it is looked to by the Ministry of Labour as setting a standard, and looked at in the community as setting a standard for what employers should be looking at for psychologically healthy workplaces. We then also have in the legal framework the Workplace Safety and Insurance Act. And we have all known the Workplace Safety and Insurance Act was very limited on how it addressed mental illness in the workplace. And generally, claims of mental illness in the workplace were not covered under the Workplace Safety and Insurance Act. We were really looking under physical injuries. If depression came about because of a physical injury, then the WSIB looked at covering the worker for wages or a non-economic loss award. And the area that talked about sort of mental stress was again very limited to mental stress arising from an acute reaction to a sudden, unexpected event. So like a gunshot. Somebody is shot in front of you in the workplace. If you have a reaction to that, that would be a sudden, unexpected event. And that, there could be a claim for WSIB benefits. And we noticed, and so if you just suffered, and there was a lot of cases on sexual harassment in the workplace, and you made a claim for mental stress to the WSIB often turned down those claims because it wasn't a sudden reaction to an unexpected event. Well, that might not be the law anymore, or at least we're having another debate. The Workplace Safety and Insurance Appeals Tribunal came out with a decision on April 29th, striking down that section of the Workplace Safety and Insurance Act, saying that it was unconstitutional. And their reasoning was that it differentiated between different forms of disability, and why should one disability from a sudden event be treated any differently than somebody who has developed something out of in the course of employment that causes mental harm to them that has created a disability. And so that case, the WSIB was dealing with a nurse who over a 12-year period was subjected to a lot of insults from a doctor in the workplace. This was the case where he told her to shoosh out of the emergency room one day and slammed the door on her. Didn't cause any physical injury. Over the 10-year period, he would insult her in front of others, and eventually she went off on what they called a stress leave and claimed for WSIB benefits. The initial level of adjudication denied her WSIB, but as it went up to the tribunal, and this was a case that started in 2006 and finally has been decided in 2014, the tribunal has said, no, we're not going to differentiate that way. That's unconstitutional. It violates our charter to say that only certain forms of disability would be recognized and not others that arise out of in the course of employment. And so they have allowed benefits going back to 2006 for that nurse. And although the tribunal decision is not binding on other adjudicators, it has now created a debate as to whether or not the Workplace Safety Insurance Act is going to change to recognize when depression is caused by the workplace, when post-traumatic stress might come out of the workplace, and other forms of mental disabilities, and then look at covering them under the Workplace Safety Insurance Act.